There you go. Yep.
I'm so used to sitting there because usually I'm going up to read or something, so.
Here we go. Hey.
We are very, very lucky today to have this very special guest with us. I'm going to read you a short resume. Bill Alexander is a native of North Carolina and a graduate of Davidson College and Wake Forest Law School. He founded and manages W.G. Alexander and Associates, an estate planning, elder law, and asset protection law firm in Raleigh. He is known locally for his radio show, called Asset Protection Today on iHeartRadio Saturday mornings. Also, he has written a book entitled Money Secrets as an experienced estate planning attorney who also provides financial and insurance advisory services. He's a retired Air Force judge advocate and is a VA accredited advisor as part of his elder law practice. He's a lawyer for over 48 years, recognized by other attorneys as AV preeminent, the highest peer rating ever achieved, and is named Who's Who of one of America's top attorneys. Recently, he was named 2023 Attorney of the Year by Top 100 Lawyers. He's been named Elder Law Attorney of the Year in North Carolina 3 times by the NC chapter of National Academy of Elder Law Attorneys. He teaches advanced elder law topics and asset protection topics for many attorney organizations, has received numerous military and civic awards, including the Legion of Merit, the Distinguished Service Medal, and Order of the Longleaf Army. And one of the highest recommendations is several members of our congregation know and use him. He is trusted. Bill Alexander, welcome.
Well, frankly, I've been doing this a long time, so there's not anything you can throw at me that I don't think that I can answer in a professional way. So now most of the time when I'm asked to speak, folks want me to talk about the kinds of legal documents that you should have and how they work and the differences that you might want to consider as we get older. Because frankly, as we get older, we need documents that are a little different, sometimes very different, from the documents that we needed when we were younger. But quite frankly, I don't want to dictate what we talk about. So if you have, I know there was a young lady who said, I have a list of questions that I want answered. Now, where are you? All right, fire away.
Do you have any advice for protecting electronic assets?
Ooh, that is a toughie. The question was advice on the protection of electronic devices.
No? Assets. Assets.
Documents,
files, etc. What
Oh.
I'm encountering with the birth of AI is that everybody wants me to use eye recognition and fingerprint recognition and biometrics. And I
Okay.
keep saying, no, 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 no. And they keep pushing it.
Mhm.
And I keep saying, no, 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 no. What can I do to protect those assets
Okay.
so that when I die,
Well, the first thing I would say as it relates to that is something that people resist, and that is using extraordinarily strong passwords. In fact, you should not be using passwords anymore. You should be using passphrases, because your passwords, if you will, need to be at least 14 characters long, need to have uppercase, lowercase, symbols, and numbers. And if you don't, then your password can act, I mean, there's black market software that can figure out a password in about a minute if you don't have a strong password. And this is the hard part, is that you should change your password fairly often, particularly on several things. And most of us are reluctant to do that as well. You should have an extraordinarily strong password for your email and for any investment or bank account that you have where you use your computer to get onto that account. Also, you need to make sure that when you go on to your investment or bank account, that you log off completely. You also need to make sure that, because depending on what kind of device you use, but most devices have cameras, and you need to make sure that you cover up your camera when you're not using it. You'd be surprised, but the fact is that bad people out there, they can oftentimes access your telephone and they can spy on you, if you will, using your own phone when you think it's off and it's not necessarily. It's getting harder, quite frankly, and a lot of folks will say use double authentication when you can, so that, and there's several different ones. I would also recommend that you use a password vault for your passwords. Does everybody know what I'm talking about? Password Vault is an application that you download on your computer and or phone, and it stores all your passwords. And it has you just have to remember one very strong, long password to get into your password vault, and then it stores very safely all of your other usernames and passwords. Another issue that a lot of folks don't realize is that if you save, when you go online and it says, do you want to save your password? If you click yes, then your password is actually stored on that device in the open. And all you have to do to see all of the passwords that you've saved is to go to your settings, to general, and then to passwords, and it will basically show you every username and password that you have saved. And very few of us do not save passwords from time to time. So it just tells you another reason why it's so important that you keep your computer and or smartphone secure for that reason. One of the better ways to secure, and a lot of financial institution and banks give you this, where you have a secondary app that runs a code every minute, a different code every minute. And so when you're trying to access that particular financial account, you put in your password, and then it requires that extra password that it is created every minute on a separate app that you go to. That helps a whole lot as it relates. But scams, and it's scary out there, and I can't belittle it. There's even software where bad people can get close. I think it's called Pegasus, where they can get close to you and clone your phone just by being close to your phone. There's some really scary software out there when it relates to that sort of thing. So now most of us, we use the same or similar password for a lot of things, and you got to get away from that. You should use very different passwords or passphrases for important things. But your bank accounts, your investment accounts, and your email account are all very sensitive, that you should be very protective of. And when we were in the military, it was ridiculous. We had to change passwords every month. We could never use the same password twice. And it had, I mean, I can't remember, but it had to be at least 14 characters. And I'm talking back in the dark ages, you know, where we had to do that because this was DOD. And the sad part was it was so difficult to do that everybody posted theirs right on a sticky note, right on their yeah, you know. But you know that's that's the kind of thing you need to avoid. But obviously, you know what the most common password is? Password. The word password is the most common. And another one is 1, 2, 3, 4, 5, 6, 7, 8, which is really sad. Obviously, those take only about a half a second to break for folks, you know, in that line of business, if you will. And so many folks don't realize, and of course, you just hope that you're not targeted. But unfortunately, it's a multi-billion-dollar business to take what's yours away from you. And the mafia is in it in a big way. Even governments, China particularly, has a whole business complex full of hackers, if you will. And so it's prevalent, unfortunately. Yes, ma'am.
One of the things I realized when my husband died and I was closing out the estate, how much I was unaware of. And so I was so very grateful he didn't use biometrics because I couldn't replicate those biometrics.
And that's why you're reluctant to do it now.
Well, somebody had to get in there and settle his estate. And so how do you accomplish that when the biometric is gone?
Well, one way is with a digital release, which is one of the basic documents that we should have, which is, it authorizes your agent to go, that basically allows you to go directly to the company that you're trying to acquire the information from, and get that information, or to change the passwords or the way to get into those documents. So
That was gonna be one of my questions, because I've been hearing so many people say, their husband, wife, whatever died, and they can't get into any of their things because they don't want to get passwords. So how is that?
well, that's because most institutions are encouraging all of us to have access electronically. They don't want to send paper anymore. It's cost savings, and for those who like computers, it's easier for them. But you bring up another issue, which is some of the things that should be done when you die, when your family members die, is to contact the credit bureaus. There are 3 major credit bureaus, and to send them death certificates in order to close out the credit accounts, because one of the techniques that bad people use is they steal your identity when you die in order to create new credit accounts and steal that way. And so that's just another, obviously shutting down any of the other accounts that folks have, but a lot of folks don't think about contacting the credit bureaus, and that can be very important. I know you have a list of questions.
Let somebody else jump in.
Okay. Anybody else have a question that? Yes, sir.
Yes, I never do banking over my phone. Am I doing a good thing?
If you use your smartphone as your computer, that's getting harder to do, actually. But certainly, There's nothing wrong as long as you don't mind going to the bank when you need to do business.
Well, I do my bank business on my desktop, iMac.
Ah, okay.
I'm a 30 years of computer job work.
Okay.
Just left me married to the desktop model.
Well, actually, not using your telephone for access to the bank app,
Yes.
at least it secures your telephone from that particular possibility of losing your telephone. Because it's much more likely that you will lose your phone than it is your desktop. And of course, there are lots of folks who intentionally will steal telephones. And of course, so if you travel a lot, then not having your bank information on your telephone is probably a good idea. So it's certainly not a bad idea.
How
Yes,
safe is it to use facial ID to log in, like I bank with Wells Fargo, and I use it on my phone, and it will do the facial ID? Is that safer than putting a
It's,
password in or not?
it is actually safer than a password. So that's not a bad idea at all. I mean, although there's one over here who doesn't like that idea. So yes, actually facial recognition is an excellent way to use it. Of course, it is helpful if you have alternative ways as well, which in most cases you can set up alternative ways other than
A lot
that.
of the ones that I log on to, like paying a bill,
Mhm.
they want to then send me a code that I put in before I can do that, which
And that's that double authentication that I mentioned just a few minutes ago that I think is excellent, that it secures that, which is a good idea.
Bill?
Yes, sir. Yes, sir.
We started off, moving on from technology,
Yeah.
we started off by talking about the things that you really need to have in place as you get older.
Mm-hmm.
And I know when you helped Jane and I, you've told us things that we never thought about.
Okay.
Is that something worth?
Yes, absolutely. I mean, you have to understand that there's so many areas that we can talk about, and I can do this for hours. So, all right, so let's talk about basic documents that everyone should have. Not everyone needs a trust. A trust can be helpful. I love to do trust, but lots of folks don't need a trust. But everyone should have 6 basic documents. One is the last will and testament. If you care about where your property goes when you die, a will help you get there, okay? It's not the only thing that is important, but it's certainly a key document. A general durable power of attorney is another key document, but let me ring the bell. I guarantee you that most of you, even if you say, I've got one of those, you don't have the right kind of general durable power of attorney. Because the bottom line is most powers of attorney that are given to you are basic powers of attorney that allow you to do certain things. Pay your bills, sell your truck, sell your house. But the problem is that those simpler powers of attorney do not authorize you to do asset protection planning, okay? And that's where they fail, because how many of you want asset protection as we get older? We don't want creditors taking our property away from us. If we ever go to a nursing home and go on Medicaid, we don't want the state to take our home or farm away from us. And if you don't have an enhanced general durable power of attorney, then you're basically handcuffing your spouse or children in terms of protecting what you have. And I can tell, because my law firm does a lot of Medicaid planning and asset protection planning, and I cannot tell you how often we have to go to court to get a judge's permission to do what we could have done had we had an enhanced general durable power of attorney. So more than any other document, it's the general durable power of attorney. For most of us as seniors, that's the document that fails more often for seniors than any other document. Then,
How do
yes.
we know that we have that?
Well, I know you have it because you came to me to get one.
Is there something stated in the document itself?
No, an enhanced power of attorney just says it's a general durable power of attorney. But typically, it will be 10 to 15 pages long. It will not be a short power of attorney. Now, just because you have a 10-page power of attorney does not mean that you have an enhanced power. But one of the significant authorities that you have in an enhanced power is the ability to gift property typically to your spouse and children. And there's about 6 or 7 ways that most powers of attorney are limited. And let me give you an example. If you're married and one spouse needs assistance, sometimes at home or outside the home, and let's say one spouse is on the downhill and the other's doing fine. In those cases, more often than not, now assuming, because you have different family situations, you have second marriages, third marriages, children, his, mine, ours, and whatsoever. But typically, what we recommend is to transfer the house or farm and property to the healthy spouse. Okay, but then we change the last will and testament of the healthy spouse to what I call a modified sweetheart will. So for those families that have what I call sweetheart planning, which is everything to my spouse and then equally to our children, which is, the most common type of plan, we changed the sweetheart will of the healthy spouse to what I call a modified sweetheart will. And instead of leaving all of the property directly to the spouse, we leave it to typically one of the children, or sometimes more than one child, as trustee for the sole benefit of the surviving spouse. Now, more often than not, the spouse that's less healthy dies first. And if that's the case, no problem, because you've already accomplished what the sweetheart will would have accomplished. All the property is already in the name of the survivor. But the worst case scenario is what? If the healthy spouse surprises us and dies first. So if we have a will-based trust called a supplemental needs trust for the survivor, then everything that falls into that trust is a protected asset. A supplemental needs trust is based on federal law, which is not going to change. Everything in that trust is asset protected. Every penny of the trust can be used for the benefit of the surviving spouse without limitation. None of it is countable for Medicaid purposes. So if the spouse is not on Medicaid, then there is no spin down of what's in the trust. So there's no 5-year look back, there's no spin down required, and typically the survivor can go on Medicaid very quickly with all of the property being protected. So yes, that's the kind of plan we like. Okay? But it obviously requires, in most cases, that we have been able to transfer all of the property to the healthier spouse in order to accomplish that. Now, we can accomplish that a couple other ways, but typically that's the most common way that it's done. Now, if you don't have an enhanced power of attorney that allows you to make those transfers, then you're stuck, and your only option at that point is to file a petition with the court and have a judge's permission to actually make that transfer. Now, I've done those petitions all over the state of North Carolina, and I've never been denied, but a judge could deny it. It's a discretionary thing, but it's the kind of thing where if it's appropriate, a judge is going to allow it. But think about it. It's much more expensive to have to go to court to do that. Plus, it takes generally 2 to 3 months to get it done while you're paying $10,000 a month for care. So it's expensive two ways. It costs money to do it, plus you're not getting the benefit that you might have gotten much earlier otherwise. Yes, ma'am.
Yes, can I ask a question? What you're answering. What if your spouse has already passed away? So you still need an enhanced power of attorney to give to one of your children?
Well, I would say yes, because, if we're talking about, now, first of all, do I think you should make gifts to your children? I mean, other than typical, normal kinds of things that we do for our children and grandchildren. The answer is no. I mean, your children are far better off inheriting your property from you than you gifting the property. Particularly what the most common thing is, well, let's transfer the house to the kids so we can protect it. That's the worst thing you can do. Okay, let me explain. When you gift property outright to your children, you're gifting them more than the property. You're gifting them your tax basis in that property. Now, some folks will, what's income tax basis? That's your acquisition cost. So, for instance, if you purchased your home in 1960 for $20,000 and today it's worth $750,000, all of that difference is what we call capital gains. And so if you've gifted that house to your children and they need to sell it to take care of you, guess what? They don't have a tax exemption for the sale of your primary residence. You could have said, your exemption, as if you're married, is $500,000 off of that gain. But your children don't get that. So if they sell the house either during your lifetime to provide money to support you, or they sell it after your death, they still pay all that capital gains tax. Whereas if they inherit that same house, they get what's called a step up in income tax basis to the fair market value of your home at the date of your death. So if the appraisal at your death is $750,000 and they sell it for $750,000, actually they would have a small tax loss, because after paying a realtor and lawyer fees and all that stuff, they would actually have a loss from the tax basis. But you see the difference? And so typically the property that most people want to give their children tends to be highly appreciated property, and that's the worst thing you can do. Now, you might say, well, how do you protect it? Well, now, there are lots of lawyers that will tell you, you need to put it in an irrevocable trust. And you're not going to hear that from me. There are times where we use irrevocable trusts. during your lifetime. Those do create a 5-year look back. There are lots of lawyers who love to do those for you. But the thing about it is, in North Carolina, if you have an enhanced power of attorney, you have options to protect your real estate without doing an irrevocable trust. I've been practicing Medicaid law for almost 25 years. I've never lost a piece of real estate yet. I mean, not any kind of real estate. The other thing about Medicaid is that your home is an exempt asset going in, but that doesn't protect it. It only means that you don't have to do anything with it to qualify for Medicaid. And your home can be worth over $750,000 and you can be on Medicaid. A lot of folks don't realize that. You can also have a Rolls Royce and be on Medicaid, but you can only have one, okay? You can have one vehicle of any value. And actually, a Rolls was not the most expensive vehicle a client of mine ever had. It wasn't because I recommended it, but they went out and bought an RV, a $500,000 RV, and said, Mom needs a rolling bathroom. So we said, okay, whatever your excuse is, that's fine. But did it pass? Yes, it passed, because that's the rule in North Carolina. One motor vehicle of any value. So, and there are lots of, and the biggest Medicaid rule that surprises folks is you can have an unlimited amount of property if it's a non-countable resource. And guess what? I can make any kind of real estate non-countable very easily. So the trick is to make property non-countable and then be able to protect it. And that.
I don't have any idea what that means.
Well, for instance, if you're married, then and one spouse needs Medicaid, and that's where you basically go into a nursing home, which I wouldn't. Nobody wants to do that, obviously, but for some families, it's not a choice. But most families, if they have professional help, can get on Medicaid very quickly. And that's, the myth is you have to spend down 5 years ahead of time, and that's not true. There is a 5-year look back. That is true, but that doesn't, most of the clients we serve are folks they come to us when mom's in the hospital going into a nursing home. That's what we call crisis planning. And quite frankly, it's very rare when we cannot get somebody on Medicaid fairly quickly. Now, for some, it might take 2 or 3 months, but typically we can preserve all of their real estate and most of their money and get someone on Medicaid very quickly. And if they have the right documents in place, then it makes our ability to do that much easier and much faster. And that's why having the right documents in the beginning is really important. And guess which document it is that helps us do that? The Enhanced General Durable Power of Attorney. Now, another common situation that we have is where we have husband and wife, they're both frail, they're both going down, but they're sticking it out. They're at home, they're taking care of each other, they're getting by, barely. The children are helping out a little bit, but basically they're doing okay, but they both know that if either one of them dies, the other one has no way of taking care of themselves at home. So what's a solution for that? Well, what we do there is tricky. We create a joint revocable trust, put all of their property in that trust. Now, the trust itself doesn't protect them at all, okay? But we're doing it and where each of them are giving what's called a power of appointment to each other, and they both create a supplemental needs trust in their will. Now, what happens with that, because, and this is another rule, you can't create that protective trust for your spouse in a trust agreement. You have to do it in your last will and testament. It sounds weird, and it is, but that's the way it is. Okay, so if we're trying to do that asset protection planning for a surviving spouse, and we have two frail people that are making pretty good until one dies, a joint revocable trust with each giving a power of appointment over all of their property in the trust, so that when the first spouse dies, they exercise the power of appointment. So all of their property is poured over to the will the trust in their will. And then they can not only take their property, but they take their spouse's property too, using the power of appointment. So everything in the trust, in the revocable trust, gets poured into the irrevocable trust at the first death for the benefit of the survivor. And bottom line is, once that's done, then the survivor is typically eligible for Medicaid if they have to go into an institution. And if they don't have to go into an institution, then the money's still available. It's being managed normally by the children. And then basically, again, every penny that's in the trust is available to care for the surviving spouse until the spouse is deceased. And at the second death, everything in the trust is available to be distributed to the children or grandchildren or however they want it distributed. So that helps. Okay,
So what does that have to do, are you saying non-countable, or are you saying non-accountable?
no, countable. In other words, in Medicaid planning, there's countable property or exempt or non-countable / exempt property. So if you're applying for Medicaid, they're not going to count your home. Your home's exempt. It's non-countable, okay? They're not going to count one vehicle, whichever is your most valuable vehicle. They will count the others if you have more than one. If you're the surviving, if you have a burial plan, if you have plots, they don't count those. If you have an irrevocable funeral plan with a funeral home, they don't count that. If you have a little bit of cash valued life insurance, only up to $10,000 of death benefit, they don't count that. If you have what's
Stocks and bonds and things.
they do count those. Those are countable, but you can make them non-countable. That's the thing. Retirement accounts are countable assets, and that's trickier. But Medicaid qualified annuities are not countable. However, they have disadvantages. They're terrible investments, but they help you get qualified for Medicaid. So and you would never use one other than for a retirement account. But that's a different issue. And sometimes I have clients where I have to tell them that they're better off not getting Medicaid because they have such a large retirement account. If I have, sometimes it depends on the client and what the life expectancy is and that sort of thing. But when you're dealing with retirement accounts, you know that when you take withdrawals, you have a high tax on it. And if you liquidate, then that generally puts you into a much higher tax bracket, which is not a pleasant thing. And so sometimes it makes more sense to use your retirement account simply to pay pay the nursing home or whatever, rather than trying to seek Medicaid. Because I always want to do the numbers to see which way works better for clients. Because sometimes it's a no-brainer not to do Medicaid planning, but instead, and using your retirement account is almost always a good idea when you're paying for assisted living or nursing care or even home care, simply because you have a big medical deduction, because people will tend to be spending, $50,000 to $100,000 a year when they have those kinds of situations. And when you're spending that much money, it's a big medical deduction, which offsets the fact that you're using retirement accounts to pay for it. So oftentimes you have very little tax issues by using your retirement account that way. Yes, Bob?
Two things. Number one, you helped Dana and I several years ago. Am I safe in assuming that you did everything you said that I should be doing? Or will you have that reviewed?
I have, well, here's the thing. I know that you have the right general durable power of attorney. And to the best of my knowledge, you and Jane are still healthy, right?
He's questioning.
I'm not talking about mentally. I'm talking,
You answered my question.
So the point is that you have documents that allow you to change what you have if you need to. And that's the flexibility is what's key for most of us as we get older. Revocable trusts, if you have a trust, can be changed. They're revocable. If you have the right kind of general durable power of attorney, you can change around who owns what property and how you own it and those kinds of things. And as long as you have capacity, of course, you can change your will as you need to as well. And typically, for us, it's the healthier spouse that needs to change their will, as opposed, depending on circumstances. Now, obviously, there are lots of folks that do not seek legal help until it's too late. In other words, we procrastinate, and that's a real negative when it comes to having the right documents in place. The other procrastination that occurs more often than not is because people believe some of the things that they're told regarding Medicaid. I've had lots of clients over the years that said, we wish we had come to you 3 years ago when we had $500,000 in the bank. Now we only have $50,000. But we were told that we had to spend this down to get on Medicaid. Terrible advice. Had they come to us 3 years earlier, we should have been able to preserve most of their money. And that sounds crazy, but I will tell you, I've got clients. Medicaid is not a net worth program. Now, you will hear, and it's true, that most Medicaid programs are for folks who are poor, okay? The Medicaid at home clearly is for folks who have very little, all right? But if you have to go to a nursing home, and this will shock you, but Congress actually intended for folks of modest wealth to be able to get on Medicaid. They used, in other words, the word for institutionalized Medicaid is medically necessary. And that's a buzzword for most of us, okay? And so I have clients that net worth might be $2 or $3 million, but they're land-rich, cash-poor. Those folks can go on Medicaid. I've never seen any real estate in North Carolina that can cannot be made non-countable. Okay, your home is automatically non-countable, but any other real estate that you have can be non-countable. And typically we can find ways, even for single people. You know, the most common way that we protect property for single people is to take their cash, you know, their investments, and you don't have to sell your investments necessarily. You can ledger your investments, in other words, not sell them. Ledger the account over to one of your children that has a lot of equity in their home, and then your child gives you a deed to as a part owner in their house. And so it hadn't cost them a nickel. You've basically given them your investment account, and they've given you a deed to the house where now you're a 50% owner in their house. And then we can give them back what we call a legacy deed, so that upon your death, your 50% goes back to them. Now, obviously, it doesn't work for everybody, because sometimes your children are thinking, we might want to move, or we need to move, or we have a big, you know, there's maybe circumstances, or the spouse is saying, no way. But the point is that that's just one method of, you know, being able to take a client's resources and making them non-countable, being able to protect them, and get someone qualified for Medicaid. So let's go back to non-Medicaid and just go talk about documents. You know, I talked about how important your will is. I talked about how important your general durable power of attorney is. You should have a healthcare power of attorney. If you have children who are over 18 years of age, you should insist they have a healthcare power of attorney. A lot of folks forget about the fact when their children turn 18. Now, we may be talking about your grandchildren here, but the point is that when a kid turns 18, as a parent, you no longer have the right to make decisions for them when they go to the hospital. So having a healthcare power of attorney is a very critical document, not only for us, but for anyone who's over 18 years of age. We should also have what's called the Advance Directive for Natural Death, often called a living will. At least those of us who are churchgoers certainly believe in that. Truthfully, I think anybody that's over 18 should have an advance directive. Quite frankly, because it's very, very limited in terms of what it does. It only applies in the worst hopeless situation. It does not apply any other time. And it's basically where when we're hopeless, don't keep us alive using artificial life support means. Just take us off, let us meet our Maker. And then the third healthcare document is simply what we call a medical release. It's actually required by federal law, so oftentimes we call it a HIPAA release, but it's to comply with the federal HIPAA law. And one of the nice things about it is that document, not only because a good healthcare power of attorney is already going to have HIPAA language in that power of attorney, but your separate HIPAA document, other than complying with federal law, allows you to have other people, normally, if your spouse is your primary agent, your healthcare document is not going to authorize your children or siblings or other appropriate people to be able to talk to your doctors and receive your private healthcare information. So we use your medical release to authorize your children and sometimes others. Sometimes it's siblings. And it also authorizes professionals that your family might hire We frequently recommend independent life care managers for seniors to act as your advocate when you go to the hospital and into rehab settings. They typically make much better advocates than family members because they know the system. They go to the committee meetings that they know about, and they know how to ask questions and to inform the committee of what you would want for yourself. And they're very reasonably priced. They're typically, depending on where you are, between $75 and $125 an hour. But that for those families that can afford independent life care manager, they're very, very good. Other families need personal injury lawyers because they've been injured, and the lawyers need access to your medical records, and it's hard to get them if they don't have a medical release of some sort. So your HIPAA release can be very helpful to you, so that you have those 3 healthcare documents, which you should take with you when you go to the hospital. And you certainly can give them to your primary care provider and any other specialist that you might go to. And then the last document, the 6th document, you've already heard me mention it, is the digital release. And that's to authorize your agent, which is normally going to be your spouse or one of your children, to use your usernames and passwords in order to do your business online. Because frankly, without a digital release, they're not authorized to use your username and password, even though families do it all the time. And of course, the other advantage of a digital release gets you past the situation that this young lady mentioned, where her husband only had bioidentical access to his accounts, and she couldn't get to them. Well, if she had a digital release, but assuming he was still alive, but the digital release also works if they're deceased, it gives you access electronically to those accounts. So that's where you have to contact the custodian of the information with the digital release. So that's your solution, quite frankly. Yes, ma'am?
What would be an example of the children having to use your name and password banking?
Oh, you're not old enough yet. Okay. So this is where you need their help. And you've asked them to help make sure your bills are paid and those kinds of things. And more often than not, they're going to go online to do that. And they're going to be using your bank account to pay your bills. Does that make sense?
Who's going to know
Who's going to know what?
that they're using?
Oh, you're saying you do this already. I see. No, I'm kidding with you. But the point is,
Know that they're using my name and
they don't. But the key is, families use usernames and passwords all the time. Do they have the authority to do it? No. Can they get away with doing it? Absolutely. Okay, so, but the point I'm trying to make is that a digital release, if you run into issues, talk to your neighbor, that's when the digital release is worth its weight in gold. Right. And see, the other thing too is that, golly day, time passes. I can't even remember when the legislature did it. I think 7 or 8 years ago. Because before that, when the banks were pushing everybody to go online, stop, we don't want to send you paper anymore. We're going to charge you more if we have to send you paper. All of that stuff. When they got people to go online, this was new for them too. And what happened was that people with authority, people who were agents under powers of attorney, they were court-appointed guardians, they were executors of estates of decedents, and the banks were not giving them access because of the fact that they weren't giving them online access. And when all of your information is online, that's a problem. And oftentimes you can go online and get historical records up to 7 years with most banks and other institutions, but can you get those in writing? Yeah, if you're willing to pay the bank hundreds of dollars, but you can get it without any problem.
Can I ask you something very quickly? Is everything you're telling us, not worldwide, but United States, or are you telling us things that are predominantly North Carolina?
Predominantly North Carolina.
So if
When
you
I
move
was
to another
talking,
state or move your mother, father, then everything needs to be looked at again, or I'm just interested in how that works?
well, my documents, I would always tell a person if they move to another state, particularly if they had will-based planning, that they should have their will, at a minimum, reviewed, because the wills we do in North Carolina are based on North Carolina law, and every state has quirky laws, really, truly. Now, beyond that, everything we do with 2 witnesses and a notary. And to the best of my knowledge, there's no state that requires more than that for the document to be valid in their state. Trusts, we design our trust to be workable anywhere in the United States or internationally if they're in a jurisdiction that recognizes trusts. Not every country recognizes trusts, but trust came out of English common law, so anywhere that is based on English common law, which is most of the world, but there's plenty of it that's not, trusts are recognized. But there are places like the Arab world and Spain and a few other areas where trusts are not recognized. But our trusts are designed to be recognized anywhere.
Bill, you told me when you created a revocable trust for Jamestown, not to put our IRAs in there.
True. You cannot, a retirement account cannot be transferred to a trust while you're alive. The reason is real simple. It would be a taxable event. The IRS would send you a bill for the whole thing. Not a good thing. Now, if a trust has retirement account language in it, then you can use your retirement account as a beneficiary designation. We generally, well, let me put it this way. Traditional marriage, you've been married to the same person forever. Your children are your children. You don't have any, outside the marriage. For those families, we always recommend just to leave it to them directly, your retirement accounts, your 401ks, IRAs, 403bs, 457 plans. Just do it directly to them and then to the children. Now, second marriages, particularly where there are children by previous marriage, we do recommend that the trust be the beneficiary, even if it's for the spouse, because that way the spouse cannot change the secondary beneficiary. So in other words, if you're leaving your retirement account to your spouse and then to your children, not her children or his children, then using your trust allows you to basically benefit your spouse but not disinherit your children. If you leave it directly to your spouse, they have the right to roll it over A spouse has the right to roll over your retirement account, and once it's rolled over, they can change the ultimate beneficiary upon their death to their own children. So obviously a trust can be beneficial, very beneficial in that kind of situation. So, or if you have children, if you have a child that you don't want to have control of their retirement account, you can use a trust for that purpose. And there are lots of reasons for that. You may have a child that is disabled or addicted or a spendthrift or married to a spendthrift. You know, lots of issues where you want to have some controls over how much they take out. Now, under the Secure Act, which was passed in 2017, we no longer have what we call stretch IRAs for our children and grandchildren, which basically means that they have to take out every penny that you've left them in the retirement account within 10 years of your death, which typically means they have 11 tax years to take out everything. And so for most people, it's okay, take out about 1/10 a year, even though that's going to be more than your required minimum distribution. And of course, you still have required minimum distributions, even though you have the 10-year rule on top of that. So it makes it a little more complicated. If you have either charitable inclinations or you have a situation where you want to stretch as long as possible retirement distributions, you can use what's called a charitable remainder trust. And with a charitable remainder trust for a retirement account, you can stretch out the annual income distributions for 20 years. It's sort of the exception to the rule. And your church or charity gets what's left over after the 20 years or when the beneficiary dies. So the charity must receive at least 10% of what you started with in order for it to work. But I'm just mentioning that because it is an opportunity, because some folks want to be able to stretch things out over a longer period than 10 years. And truthfully, if you look at the numbers, generally speaking, your child will get about the same amount of money over 20 years that they would have gotten over 10 because of the difference in taxes. So the charity's ending up getting the benefit at the end of the day. But it's 20 years down the road. Charity doesn't get a nickel for the first 20 years. So.
Just another question.
Oh, yes, ma'am.
Yes, how do your children prevent having to do probate?
Well, a revocable trust is a very common way to avoid probate. Now, just to get technical on you, probate is simply where the clerk takes a piece of paper and says, this is your last will and testament, and puts their stamp of approval on it. The rest of it, which most of us think of probate, is actually court administration. So it's the court administration that you're trying to avoid. And now, I'm going to say this very carefully because you have to understand that to use it or not, how you use it. But you can do beneficiary designations on almost any kind of property you have. You can, bank accounts, they call them PODs, pay on death. Now, which comes first, the will or the bank contract? The POD comes first. So, in other words, you can destroy a will-based plan with beneficiary designation. You can destroy a trust-based plan with beneficiary designation. So you have to understand that whatever plan you have needs to be consistent with what you are doing. And I can guarantee you from a lot of experience that your banker doesn't have a clue what your plan is, and your financial advisor oftentimes doesn't have a clue what your plan is. Now, a really good, if you have a large account, a really good financial advisor will contact your estate planner to make sure that whatever they're doing coordinates. But there are a lot of folks who don't make those phone calls, and I've never had a call from a banker, ever. So I can also tell you a horror story about a beneficiary designation. I had, and this is back into a Medicaid case, but I had an older couple. The wife was very sick, had to go to nursing care. We had preserved his home and about a little over $500,000, which most of it was at the bank. And Mr. Smith was getting older, and you know, when he went into the bank, his banker said, "Oh, Mr. Smith, you need to fill out a beneficiary designation so you won't have to go through probate." Guess what? He did what the banker suggested, and it cost his family $350,000. Because she was already on Medicaid, and that banker took her off of Medicaid when he died. And he died first. And like I said, now, he could have done the beneficiary designation to the trustee under his will, and that would have solved the problem, but the banker didn't know that. He didn't know what to tell Mr. Smith, if you will, and of course that's not his name, but I'm just simply saying that those are the kind of things that happen because the professionals are not talking to each other, which is a huge problem. You can do this. You can do the same thing with a financial account at the brokerages. They're called TODs, transfer on death, but it's a beneficiary designation. Of course, your life insurance will already have a beneficiary, which you can change, and your retirement accounts will have a beneficiary, which you can change. And for most people, that's most of what we have. Okay. So anyway, that's, now, a lot of folks say, well, do I need a trust? And I will tell you, I've probably had 5 cases this past 2 weeks where I've say, you know, the folks have come in and said, I think I need a trust. I've been told I need a trust. And I look at their resources, and they have a really nice home. They have $1 million retirement account, and they have about $50,000 in the bank. And my first thing is, no, you don't need a trust, because and this surprises people, but of course the retirement account's a beneficiary designation. Real estate in North Carolina is not a countable asset for court administration, for probate. Okay? So if your will says, I leave my home to my 3 children, the moment your will is probated, the home belongs to the 3 children. It doesn't require a deed. It is not administered in court. The court does not charge a nickel for the fact that you have a nice home. In other words, it's not a countable asset. The only time real estate can be countable, and this is any kind of real estate, is when there's not enough money to pay the creditors, to pay the bills. If that's the case and the only asset in the estate is the real estate, then the executor has to petition the clerk to bring the real estate in to sell it to pay creditors. But if the creditors are paid, you know, all the bills are paid, then the real estate is not touched. So the bottom line is probate the will and you're done. Okay. Yes, ma'am. Yeah. You're expecting more.
But, is that a good idea, or should you separate it in parcels for them?
No, I think the best way to go is to say equal division.
Okay.
All right, and the worst case I've ever seen, to give you the other side of that coin, had a case probably 10 years ago, and I was asked to go see grandmama, and her husband had died 15 or 20 years earlier. And before he passed, their plan was they had 3 big assets. They had a very nice home in Cary. They had, which at the time was worth maybe $250,000. They had 80 acres of swampland in eastern North Carolina that was basically duck hunting property with a hunting cabin on it, which was worth about the same. And they had a beachfront house, I can't remember what beach, but any beach, that at that time was worth about this, all 3 properties worth about the same. They had 2 daughters and a son. So their will said swampland goes to the son, beachfront property to one daughter, Cary house to the other daughter. Guess what happened over the next 20 years? Beachfront property was worth $1 million easy. The Cary house was worth maybe $350,000, $400,000, and the swampland was still worth about the same. Well, the good news was the son didn't care because he was financially well off. Went to grandmama and she said, nope, that's what Dad wanted and that's what we're going to stick with. I begged her to change it to equal division. And as a result, do you think the daughters talk to each other anymore? No. No, it's, that's the kind of thing you can get when you decide in advance how it's going to go. Because truthfully, the kids can work it out, and that's a much better way to go.
So does the trust protect you legally from?
A revocable trust gives you absolutely no protection whatsoever. A trust is a fantastic planning document for your family. It can, a well-written trust gives you a disability plan that gives your children fiduciary obligations to spend your money on you the way you want it to be spent if you can't manage your property anymore. But more important, and you can choose whether to have a sweetheart plan for your spouse or to have an irrevocable asset protection trust for your spouse. Now, obviously, if it was a second marriage, you would always do the irrevocable trust. But some of my younger clients who are wealthy, they use the irrevocable trust at the first death primarily to have what we call remarriage restrictions on the surviving spouse. Now, it doesn't mean that they can't remarry. It simply means that if they remarry, the trust that's created basically turns off or turns down in terms of what they can get out of the trust. But typically they can't be the trustee anymore and the children step up, and it's basically a way to preserve assets for the children as opposed to the spouse. And then you can do much better tax planning depending on your wealth. Most of us don't have to worry too much about death taxes at this point, but you can, well, I hate to put it this way, but one of the key reasons that most of my clients use trust today is to create a lifetime asset protection trust for each of their children. And you might, sometimes it's because the children are in risky professions like doctors, lawyers, dentists, architects, engineers, things like that. But more often, it's because what are we worried about as it relates to our children? the potential for divorce. You know, divorce is so common today. It's about 50-50 in terms of the possibility of a divorce. And so the point is that most of us do not want what we leave our children to be subject to a petition for equitable distribution in a divorce. And we know if we leave an irrevocable asset protection trust for our child, it's not marital assets. It will not be divided in a divorce. It'll be maintained by your child. So for those of us who have a reasonable amount of money that we're leaving to our children, to do it in a trust that they control themselves is a pretty good option. And the other thing that's really nice about a lifetime trust is that you can also control what happens to the remaining trust at the child's death. In other words, that it goes to the grandchildren rather than to the spouse. And that's and you can also do generation skipping planning and things like that. So trusts give a lot of options that folks don't have. And I would just as a general rule, if you have real estate outside of North Carolina, if you have a business, a corporation, or LLCs, if you have any kind of family issues, those run the gamut, then a trust is normally a better plan. If you have a really nice estate, then generally a trust is going to give you a better plan than a will-based plan. So, but you can, as you've already learned, you can use a trust and a will together to give you the best planning option. I have cases where we have a revocable trust that pours into a will-based supplemental needs trust, then pours back to the joint trust to be distributed to the children in irrevocable trusts. So that's not an uncommon plan for us as well. Susie?
We've kept you for an hour and a half.
Ah, okay. Well, see? I told you I could talk for a long time. Did I have any last questions?
Let me ask you something. You suggested we all get a digital release, and I think that that needs a lawyer. No, what does that mean? How do we do
I don't know if you can find one in a book or not. And there are a lot of lawyers that still don't do them because they don't know about them, even though they should. I mean, I've reviewed documents that were done.
I can't just write that down on a piece of paper. I gotta have it.
No, you need to do it. It needs to be a legal document of some sort.
And what about if you're not sure that something was done a number of years ago, should you go back to your original lawyer? Like this, I don't know that I've got an enhanced whatever.
You
Should
probably
I-
don't. It's easy. If all elder law attorneys are estate planners, but they're general practitioners, and estate planners are not necessarily elder law attorneys. It's far more likely that you'll get an enhanced general durable power of attorney from an elder lawyer, because elder law attorneys are focused on seniors and senior issues, particularly relating to Medicaid and asset protection and things like that, where estate planning attorneys are typically more focused on tax planning. Yes, ma'am.
One more question. So I have both my girls' names on my safety deposit box, on my checking account, and on several other accounts.
That works as well. If you have a simple estate, that works. One thing you might do in your safety deposit box, if you have valuables in there, is to wrap them up and put one girl's name on some of it and the other girl's name on others. So it makes it clear that this belongs to one child. And my mother did that, by the way.
It's mostly papers, you know.
Okay, well, do not keep your estate planning documents in a lockbox. And that's a catch-22 situation, because when you need your documents, you can't get them. So do not use that. So anyway, it has been a pleasure. I hope this has been okay. Yeah, thank you. Pleasure. Okay. I know y'all are ready to go home.